Good morning, everybody. Nice summer's day outside, so we'll press on with the Countryside Rights of Way panel for the 16th of August 2024. We'll start, please, with the apologies.
Thank you, Chair. Yes, I've received apologies from Councillors Jack Abrahams, Jill Waring and David Williams. Thank you.
Thank you so much. Any declarations of interest from members? No? Okay. No. Item number 3, minutes of the meeting held on the 9th of August 2024. Moved? Agreed? Caroline, are you okay with that?
I wasn't here, so, but I did watch it online.
Well done for your persistence. So I'll just sign these. I've got a copy in front of me. There you go, thank you. Okay, and we'll move on to item number 4, which is the first application, Wildlife and Countryside Act 1981, an application for the addition of a public footpath from Brockhurst Lane to Blimhill and Weston under Lizard. Is it Hannah or Becky?
It's me.
Becky, thank you.
Thank you, Chair and members. So, as mentioned, this is an application for the addition of a public footpath from Brockhurst Lane to Blimhill and Weston under Lizard, Bridleway 14. The line of the route can be found at Appendix A. I can confirm that we've received no objections or representations from the local member. And the recommendation from your officer is that the evidence submitted by the applicant is insufficient on the balance of probabilities or to reasonably allege that a public right-of-way with the status of footpath, which is not shown on the definitive map and statement, shown marked A to B on the plan attached at Appendix A to this report, exists. And I also recommend that an order should not be made to add the alleged public right-of-way shown A to B on the attached at Appendix A to the definitive map and statement of rights-of-way for the district of Blimhill and Weston under Lizard with the status of footpath. So this application was based on historical evidence, and the applicants submitted a selection of historical documents to support their claim. Firstly, the applicant has provided a traced copy of the Blimhill Enclosure Award dated 1827, which shows the western end of the alleged route. As members know, Enclosure Acts were designed to enclose the old commons, manorial waste and smaller holdings in order to increase agricultural productivity. They were private, local and general acts. The local enclosure acts were limited in application and were specific to one area. The documentation provided by the applicant appears to show the western end of the alleged route as a dashed line, marked C and annotated to read, from Church Eaton. It gives little indication as to the status of the alleged route or the nature of the rights over the route. As the applicant only provided a small copied section of the enclosure map, your officer attended the Records Office to view the original documentation and additional wording. A copy of this can be found at Appendix C. The award is dated 1827, meaning that the standard clause of the 1801 Act are applicable. On inspection of the award, there is nothing to suggest that there are any of the 1801 provisions excluded. The award states that the Commissioner, Valentine Vickers, had the powers to set out and create public and private roads. And it states, I, Valentine Vickers, do set out and appoint several public and private roads upon and over said common wastelands. The award map shows the route is marked with the letter C, and when we look at Schedule A, we can see that this details the route as being a public footpath owned by Blimhill Parish Council. The award does not state that this is a newly created route, meaning this was considered to be a route already used by the public. So we'll move on now to the deposited railway plan. And as members know, when major works are planned, such as building of canals or railways, the intended route would be surveyed. From the surveys, plans and books of reference were compiled, which showed who owned the land crossed by the proposed canal or railway. This then formed part of an Act of Parliament. Statute says, sorry, I'm having computer issues there. Statute required from 1838 that the plans of these works and the accompanying book of reference were deposited with the local public authorities. This was true for routes that never came to fruition, as well as for those which were constructed. In compiling the plans for the route of the railway or canal, the surveyors drew up a map showing the intended line of the construction with the limits of deviation from that line. It was not the primary purpose of deposited railway plans to record highways of any description, but came about as a consequence of the need to survey the land. The plan allotted plot numbers to each strip of land affected by the passing of a canal or railway. The book of reference listed who owned the land crossed and the type of land, e.g. whether it's agricultural or highway. When we look at the evidence provided by the applicant, we can see the full extent of the alleged route. It is clearly shown and annotated with the number 34A. On inspection of the book of reference, we can see that 34A is detailed as being a footpath, and the owners are stated to be Blimhill Parish Council, supporting the contention that this was a public footpath. The alleged route runs from plot number 31A in the north-easterly direction before joining 37A. It passes through arable and pasture land. The book of reference states that 31A was a public road owned by Shifnal Rural District Council. 37B is detailed as being arable land owned by the Earl of Bradford, and 37A, which was referred to in the book of reference as being a footpath owned by Blimhill Parish Council. As the alleged route is shown connecting to a public road to the west and a public footpath to the east, this is good evidence to support the alleged route being public. It is unlikely that the route would connect to a public highway and a public footpath if it did not have the same public rights over it. Furthermore, the book of reference refers to the route as a footpath and states that this is in the ownership of Blimhill Parish Council, supporting the contention that the route is a public footpath. The applicant also provided an Ordnance Survey map dated 1884. As members know, Ordnance Survey maps provide excellent evidence of the physical existence of the features they show at the time of the survey, but they are silent on matters of status. The alleged route is depicted on a copy of an Ordnance Survey map dated 1884, and the route is annotated with FP. This shows the physical existence of the route, as I mentioned, as a footpath. However, it cannot be relied upon to infer public status. So when the application was initially received, landowners were contacted, and this was in 1999, but no response was received. However, upon circulation of the draft report on the 25th of March this year to all interested parties, the landowner submitted evidence which showed that this route had already been considered at a public inquiry and had subsequently been rejected. As part of the 1949 Act, all county councils had to provide a map of the area showing the public right-of-way that were reasonably alleged to exist. Information relating to the public rights-of-way were provided by district councils through parish survey cards, and as a result of the draft definitive map was drawn up. The draft definitive map was subject to objections and special review, which often resulted in public inquiries to determine their existence. In this case, it appears that the County Council considered a footpath existed along the line of the applied route and that it should be included on the definitive map. The Council submitted in support of their route the same evidence that has been considered in relation to this application, the enclosure award, deposited railway and deposited railway plan, which was submitted by the Ramblers Association. At the time, this was considered good evidence in support of the claim. The deposited railway plan showed the route and the enclosure award showed part of the route as a footpath. However, the landowner objected to the route's inclusion, and an inspector on behalf of the Secretary of State considered the evidence put forward. On review of all of the evidence and taking into account the landowner's objection, the inspector did not consider that the enclosure award and deposited railway plan was sufficient and convincing grounds to include the route. It was therefore decided that the route would not be included on the definitive map. For this reason, the route has never appeared on the definitive map since the special review. As the inspector's decision still stands and is binding, and there is no evidence to suggest that the decision has ever been overruled, we cannot consider evidence that has already been determined at planning inquiry by an inspector. Officers contacted the Rights of Way team to confirm that these documents were true copies of the original. The team supplied a full copy of the 1977 inquiry report. This showed the information sent through by the landowner was indeed a true copy, and copies of the landowner evidence and the full report can be supplied by the Rights of Way team can be found at Appendix F. So, to summarise, the application was made under Section 53(2) of the 1981 Act, relying on the occurrence of events specified in 53(3) of the Act. In this instance, the applicable section of the Wildlife and Countryside Act 1981 is Section 53, brackets 3, brackets C, brackets I. The application is to add a footpath which is not already shown on the definitive map and statement. The alleged route runs from Brockhurst Lane in a northeasterly direction and joins Bridle Way, 14, Blimhill and Western under Lizard. The enclosure map shows the western end of the route. In the award is described as, as a public footpath. Although the full extent of the route is not shown on the enclosure map, it is good evidence for the western end of the route, and it is possible that the full extent of the route did exist at this time. The deposited railway plan, dated 1883, shows the full extent of the route. It clearly shows the route in the accompanying book of reference as being noted as a footpath owned by Blimhill Parish Council. Railway plans were put on deposit, thus giving the public and landowners chance to object to this, and they didn't at the time. The Ordnance Survey map, dated 1884, shows the alleged route in its entirety and shows it following the same line as the claimed route. Although the map provides no indication as to whether the route was public or private, the route has the annotation FP alongside it. The deposited railway plan and the Ordnance Survey map clearly show the alleged route. Although we cannot see the full extent of the route in the enclosure award, it does clearly show the western end of the route and appears to follow the same line. However, when we consider the evidence submitted by the landowner, we have to honour the decision that was made in 1977. The same evidence was submitted in 77 and considered by Secretary of State. An objection was made by the landowner and subsequently this objection upheld. Therefore, although the historical evidence has been presented as supporting the route's physical existence, as this evidence has already been considered at planning inquiry and considered by an inspector, the evidence cannot be considered again. As the evidence was judged to be insufficient to support the route's physical existence as a footpath, this decision remains. So, to conclude, when the totality of the evidence provided by the applicant and the landowner is considered, it is your officer's opinion that the County Council should not make a modification order to add the footpath to the definitive map and statement of public rights of way. Thank you, and I'm happy to take any questions.
Thank you, Becky. A very well put together presentation, and I think it's sort of it's fairly cut and dried. David.
Thank you, Chairman. Just a couple of points of clarification. We have mentioned in the report two different owners of this land. It says that the Parish Council own it, but also that it's a cross land owned by Lord Bradford. Who actually owns the route?
It is Lord Bradford.
Not the Parish Council?
No.
I was only interested because if the Parish Council owned it, one would have thought that they would have been supporting the footpath as an existing way. Could I just clarify, it may sound a silly question, but because of the nature of the things that we deal with here. Does the footpath actually physically still exist?
No,
It doesn't.
no, it doesn't.
No, that's what I thought. Thank you
Yeah.
very much indeed. Thank you for your report.
No problem.
Yeah, just very quick question. When this has gone through so much in the past, why are they even allowed to resubmit saying that they want this to change again? This is, to me, this is like a planning application for a house next to you. You don't want it, it goes to appeal, it ends then. But now we're still carrying on. I don't quite understand that.
Well, I think in this case, the information relating to the objection and everything wasn't readily available to the public. It wasn't even readily available to us. It wasn't until the landowner contacted me and said, well, I've got this, that I then went to the Rights of Way team and said, can you shed any light on this, basically? And then they produced the full report for me. But yeah, it wasn't something that the public can easily gain access to.
Carol, you'll learn very quickly. People are paid to put these applications in, so even if there's things that have been said, like in 1977 when the Secretary of State review was, they still put them in because they get paid for putting them in by various organisations. It is, but that's nothing we can do about it, really. Nice things. I'd like to make a proposal that we go with Of's recommendation. Well, as it's basically got insufficient evidence and balanced probabilities, but that's irrelevant, really, as there's no new evidence to overrule anything the Secretary of State said in 1977, so that is my proposal.
I've got a proposer, seconder, and we're all in favour of going with the officer's recommendation. I don't think we're allowed to overrule the Secretary of State. It's sort of... yes, by the Secretary of State. So yes, thank you for the report, and that was very important information, and I'm glad it came up. Okay, we'll move on now, please, to item number 5, which is again Wildlife and Countryside Act 1981, and it's an application for the addition of a public footpath between Public Footpath 28, Longston, and Villa Road, Cheddleton.
Yes, thank you, Chair, members. So yes, this is an application for the addition of a public footpath between Public Footpath 28 Longston and Villa Road in the parish of Cheddleton. The line of the route can be seen at Appendix B and is marked A to B. The application was submitted by Cheddleton Parish Council and was submitted based on user evidence. So to begin with, if we look at the user evidence, originally 14 user evidence forms were submitted. A further 7 user evidence forms were submitted at a later date. Therefore, in total, 21 members of the public have provided evidence of use of the alleged route. The alleged route runs from Public Footpath 28 Longston in the north to Villa Road at the boundary of what used to be St Edward's Hospital to the south. Where an application has been submitted based on user evidence, the evidence needs to be evaluated under both statute and common law. Section 31 of the Highways Act 1980 sets out the tests that must be satisfied under statute for a way to become a public highway through usage by the public. The usage needs to be as of right and without interruption for 20 years, unless there is sufficient evidence that there was no intention from the landowner during that period to dedicate the route to the public. The 20-year period is calculated retrospectively from the date that use of the route is brought into question. Where there has been no obvious challenge to use of the route, the date of the modification order application is taken as the date of challenge. In this case, there has been no obvious challenge to use of the route, and therefore the 20-year period has been calculated from the date of the modification order application, and the relevant period of usage is therefore from 1978 to 1998. Only one user has used the route for the full relevant 20-year period. However, 12 users have claimed to have used the route for over 20 years, just not completely within the relevant 20-year period. This could in part be because the users completed user evidence forms 1 to 2 years prior to the application being submitted. No obstructions have been identified along the route, although there is mention of stiles and gates at the railway track, the river and canal, but there is no suggestion in the user evidence that they posed a hindrance to use of the route. When viewed objectively, stiles would be considered to assist walkers. One user has claimed to have used the route for work purposes, which would suggest implied permission, but the remaining user's evidence shows the use was as of right. It was not done in secrecy, by force, or with permission. The frequency of use by the users is fairly low. When considering the evidence under common law, it is for the user to prove the owner dedicated the route, and the use does not have to be for 20 years. On review of the evidence, there is a reasonable number of people who have claimed to have used the route for a significant period of time, with the evidence showing that the route has been used in excess of 20 years by some users. Photographs have been provided by the applicant that show that at the time the photographs were taken, there is a route on the ground which could be used by members of the public as a footpath. Turning to the landowner evidence, Severn Trent Water have been identified as a landowner, and they have advised that the alleged route is a private right-of-way. They have advised that in 1911 there was an agreement in place with the relevant body representing the hospital, stating that the footpath was a private right-of-way for those accessing the hospital. This was further set out in a lease between Staffordshire Potteries Water Board and the North Staffordshire Hospital Management Committee in 1958. Severn Trent Water claimed that a sign was erected stating that the footpath was private. Stiles and gates were also erected along the route, including a footbridge across the River Churnet in 1958. There is no evidence to suggest that a private sign was not erected. However, the evidence supports the sign being erected in 1911, and there is no clear evidence that the sign was still in situ at the time the users claimed to have used the route. None of the users refer to a private sign. Due to the length of time that had passed, the sign may no longer have been in place, or may no longer have been in a place visible to the public. The evidence shows that historically there was a path on the ground that could be used by people on foot, but that the intention of the landowners at the time was that the path was only to be used by people accessing the hospital. Parish survey cards have been obtained for public footpath 28 Longston, which the alleged route would connect to in the north, and a public footpath 41 Cheddleton, which follows the same line as the alleged route. The parish survey card shows public footpath 28 Longston is longer in length than is currently depicted on the definitive map and forms part of the alleged route. The parish survey card for public footpath 41 Cheddleton shows this route continuing from public footpath 28 Longston and following the line of the alleged route to Villa Road in the south. Parish survey cards form the basis of the first draft definitive map. Objections could be made to the inclusion of a route on the definitive map, and public footpath 41 Cheddleton was objected to by Staffordshire Potteries Water Board on the grounds that the path was a private footpath and not a public right-of-way. This objection was upheld, and an order was made to remove public footpath 41 Cheddleton from the definitive map. Despite the original extinguishment, evidence has been put forward that members of the public have since used the route as a footpath, and therefore a right-of-way has been re-established across the alleged route. Also, there is no evidence from the landowners that during the period the users are alleging to have used the route, that any action was taken to continue to rebut any presumption of dedication. No statutory declarations made under Section 31(6) of the Highways Act 1980 from any landowners have been found during the period of use between the 1970s and 1990s. When considering comments from other organisations, Staffordshire Moorlands District Council responded stating that the council's planning committee support the addition of the alleged path. The Peak Northern Footpath Society advised that they accept the application. The footpath secretary from the Ramblers Association advised that they have personally walked the alleged route many times in the past. They advised that it is a good footpath walk from Cheddleton to Leek and is also a footpath which leads to Walgrange Country Park. The alleged path is used by people walking to work and is well defined on the ground. Turning to the relevant legal tests to be applied, the application is made under Section 53, 3C1 of the Wildlife and Countryside Act 1981. Therefore, there are two tests to be considered. Firstly, whether the evidence shows on a balance of probabilities that a right-of-way along the line of the alleged route subsists as a public footpath, or a lesser test of whether on review of the evidence it can reasonably be alleged that the route subsists as a public footpath. To summarise, the level of use of the route is fairly low, albeit a reasonable number of people have provided evidence of use of the route in excess of 20 years, supporting a reputation of the route as a public footpath over a significant period of time. Evidence has been put forward showing that historically the landowners intended that the route should be a private footpath, providing access to those people needing to access the hospital situated at the southern end of the route. There is also clear evidence that at the time of the first draft definitive map, a decision was made that a legal order should be made to ensure that no public footpath rights existed along the route running along the same line as the alleged route. However, if evidence comes to light that members of the public have since used and asserted a right subsequent to any legal order, and that use meets the relevant legal tests, then it can be argued that a public right-of-way has been re-established, as with this application. There is no clear evidence that during the period of use, the landowner took action to continue to show to members of the public that there was no intention to dedicate the way as a public footpath. Therefore, whilst the evidence of use is insufficient to show on a balance of probabilities the existence of a public footpath, the evidence is sufficient to reasonably allege the existence of a public footpath along the line of the alleged route. Therefore, to conclude, Office's recommendation is that an order should be made to add the route subject to this application to the definitive map and statement as a public footpath with a minimum width of 1 metre. Thank you, and I'm happy to take any questions.
Thank you, Hannah. Very interesting. Just a quick one for me. The history side of these applications and the social history and the things we hear about. I mean, it's 60 years ago and it's talking about lunatic asylums, and it does show how we have moved on as a society from those dark days. David, you wanted to speak on this, please?
Chair, I just want to clarify a couple of points, really. Is the railway still in active use? I mean, I see there's barriers and all sorts of things that are up. Does that indicate the closure of the railway line as an active line? And I see on one of the plans there is a gate across the footpath. Is that gate one that can be opened easily, or it has to be climbed over, or do we know anything about the gate?
So in relation to the railway line, that is no longer in use. In relation to the gates along the route, there's been no evidence put forward by any of the users that the gates have posed any hindrance to use of the route. So, for example, that they've had to climb over them, and the landowners have not provided any evidence to say that any gates along the route are locked that would obviously prevent people from being able to get through them. So based on that, based on the evidence, there's nothing to suggest that those gates have posed a hindrance to people using the route on foot to get through the gate.
Could I just cut in and just follow on from what David's just said? There was an indication that one of the railway lines around Leek was to be reinstated. Is this one is the first question, and if this is the one that they're talking about, if we put an order in, does that affect reopening the railway line? Are we creating work for another committee in the future?
I'll be honest, I'm not 100% sure whether the line in question that you refer to is potentially being reopened affects the line that's subject to this application. In terms of this application, we are merely just establishing whether a public footpath exists, exists, and therefore, unfortunately, at this panel, we can't take into consideration any potential future development works that may take place.
Thank you. Paul?
I'm sure that this is the footpath that the new Labour government says will not go ahead. It's just going to be used the money that was being given back by HS2 to reopen this line, and they've now said this path will not go ahead to the detriment of the moorlands really and Leek.
Well, as Hannah said, if we can't actually look at that over, but it's good that we've brought it up and highlighted it. Anyone else want to, Carolyn?
Yeah, not really. I'm happy to move this as officer's recommendation. I think it's very clear by the amount of people that have written in that it's been used consistently over, like you said, the last 20 years.
Seconded by David. Thank you. All in favour? Okay, so we've going with the officer's recommendation on that. Thank you. And we'll move on, please, to item number 6, which is the Wildlife and Countryside Act 1981 application for the addition of the alleged public footpath 89 Biddulph Town via Mill Cottage to Hurst Road, Biddulph. Hannah again.
Yes, thank you, Chair,
Thank you.
members. So yes, this is an application for the addition of a public footpath from public footpath 89 Biddulph to Hurst Road, in addition to an application to modify the particulars in the mapping statement which require modification in relation to public footpath 89 Biddulph. The application was submitted by the Open Spaces Society and was submitted based on historical and user evidence. The line of the routes can be seen at Appendix B. The route marked A to B to C has been submitted as part of the application to modify the particulars of existing public footpath 89 Biddulph and also as an addition. The route marked B to D has been submitted as an addition to the definitive map only. So if we look at the route marked A to B to C first and the evidence put forward to modify the particulars of public footpath 89. The current definitive map shows public footpath 89 commencing from Grange Road to the west and following an easterly line. The route terminates south of Mill Cottage and it does not connect to another public highway to the east, meaning that the route is currently a cul-de-sac route. The applicant has provided a copy of a map which may have been produced at the time of the draft definitive map. It shows public footpath 89 as a single broken line with the annotation path written alongside it. The applicant has also provided an extract from the definitive statement which records the path commencing at Congleton Road opposite Talbot Hotel and the path finishing at road about 150 yards northwest of Elmhurst. This is how public footpath 89 is currently recorded and has always been recorded on the definitive statement. However, the current map and statement do not correspond with each other, as the map does not show public footpath 89 terminating at the road northwest of Elmhurst. At the time of the first draft definitive map, a parish survey card was completed for public footpath 89, and the description provided on the survey card is supportive that the public footpath continues to the road at Elmhurst, which would be Hurst Road. Enquiries were made as to why public footpath 89 terminates where it does on the definitive map. No known definitive maps have ever shown public footpath 89 connecting to the public highway at Elmhurst. However, the county did try to add a connection. When the council was reviewing the parish survey maps and cards in 1954, it noticed that Biddulph 89 was a cul-de-sac route on the map, but the survey card said it ran through to the road. In an attempt to correct this, the survey map was appended with extra lines that were coloured green. A green line is showing running along the line of A to B to C, and a note was made to amend the definitive map. The key states that routes coloured green were paths not originally shown on survey, which it is proposed to include in draft map. This amendment was never made and never figured in the objection process. The evidence supports the contention that the alleged route marked A to B to C was to be added to the definitive map as a continuation of public footpath 89. However, this recommendation was not taken forward. No evidence has been found as to why it was not taken forward. An order can be made to modify the particulars in the map and statement where there is conflict between the map and statement. The intention of these orders is not to change the status of the way or question its public rights, but to correct inconsistencies. The map is conclusive evidence as to the existence and status of any right-of-way shown, whilst the statement is conclusive evidence as to the position, width, and any limitations or conditions. Where there are inconsistencies, the evidence submitted when the route was first put on the map, how the way is depicted, and also the particulars in the statement need to be considered. It is clear that at the time of the first draft definitive map, a public footpath was considered to exist along the line of existing public footpath 89, and a decision was made that this footpath should connect to Hurst Road to the east and continue along the line of the route marked A to B to C. However, public footpath 89 has never been depicted on the definitive map in this way, despite the fact that the definitive statement has always referred to the footpath terminating at Hurst Road. Therefore, it is argued that the definitive map should be amended to reflect the decision made at the time the parish survey evidence was produced and to correspond with the statement. Turning to the user evidence, 12 members of the public submitted user evidence forms claiming to have used the alleged routes. All 12 users have claimed to have used the route marked A to B. 10 users have claimed to have used the route from A to B to D, and 2 users claim to have used the route A to B to C on foot. Where an application has been submitted based on user evidence, the evidence needs to be evaluated under both statute and common law. Section 31 of the Highways Act 1980 sets out the tests that must be satisfied under statute. The usage needs to be as of right and without interruption for 20 years, unless there is sufficient evidence that there was no intention from the landowner during that period to dedicate the route to the public. The 20-year period is calculated retrospectively from the date that use of the route is brought into question. The evidence shows that there was an obvious challenge to use of the route in 2015. Therefore, the relevant 20-year period is from 1995 to 2015. 6 users have claimed to have used the route A to B to D for the relevant 20-year period, and none of the users have used the route A to B to C meet the full relevant 20-year period. The frequency of use is fairly low, given that only 2 users claim to have used the route marked A to B to C on a daily basis, and for the route marked A to B to D, only 2 users claim to have used the route weekly, and 2 users claim to have used the route monthly. It is clear from the evidence that in 2015, the landowners took steps to prevent members of the public from using the routes as footpaths by erecting private signs and having locked gates. None of the users claimed that their ability to use the routes was hindered prior to 2015. A number of users have stated that the previous owners of Mill Cottage, who owned the land during the relevant 20-year period of use, were aware of members of the public using the alleged routes, and they did not take any steps to prevent members of the public from using the routes. This is in contradiction with the landowner evidence, which states that anyone seen using the routes were asked to turn back or were given permission to continue along the path to Hurst Road. This is stated in a statement that has been provided by a previous landowner who owned the land for 6 years of the relevant 20-year period. Evidence has also come to light that the landowners who acquired the land in 2001 built a retaining wall around part of the garden to the property. From the evidence provided and the County Council's mapping, it would appear that this wall would have encroached on the route marked B to C, but the route marked B to D would fall just to the west of the retaining wall. This may explain why the evidence of use for the route of for B to C is so small, as it would appear that it was not possible once the wall was built to walk this route to connect to public footpath 89. When considering the evidence under common law, it is for the user to prove the owner dedicated the route, and the use does not have to be for 20 years. On review of the evidence, there is a reasonable number of people who have claimed to have used the route, specifically A to B to D, for a significant period of time, with the evidence showing that the route has been used in excess of 20 years by some users. A range of historical evidence was submitted with the application, but overall this evidence was not supportive enough to show that the applied for routes have existed historically as public footpaths. The landowners object to the application, and their full response can be seen at Appendix BB. They argue that the historical evidence does not support the existence of these routes as public footpaths, and historically anyone seen using the path has been told to turn back or given permission to continue up to Hurst Road. Biddle Town Council also responded to the application, stating that they support the application. They argue that the routes have been an integral part of the Staffordshire Moorlands Western Edges Walk. They further advise that the original footpath ran along the route marked A to B to C, and this has been supplemented by a shortcut along the line of the route marked B to D. They are also of the view that historically there is evidence to show the existence of the routes as public footpaths. Turning to the relevant legal tests to be applied, the application has been submitted under 2 sections of the Wildlife and Countryside Act 1981, that being Section 53 3C1 and 53 3C3. In relation to the application to vary the particulars of the map and statement for public footpath 89, it needs to be shown on the balance of probabilities that it is more likely than not that the definitive map and or statement is wrong. The existing description or depiction of the route must remain unless and until the panel is of the view that it is more likely than not that the current description or depiction on the path shown on the definitive map and or statement is wrong. In relation to the section of route applied for as an addition, there are 2 tests to be considered. Firstly, whether the evidence shows on a balance of probabilities that a right-of-way along the line of the alleged route subsists as a public footpath, or a lesser test of whether on review of the evidence it can reasonably be alleged that the route subsists as a public footpath. So to summarise, in relation to the section of route marked A to B to C, on the balance of probabilities there is sufficient evidence to show the existing line of public footpath 89 should continue along this line. There is a clear discrepancy between the map and statement for public footpath 89, and the evidence supports that a decision was taken that public footpath 89 should continue to meet Hurst Road along the line of the route marked A to B to C, and therefore on the balance of probabilities the map should be amended to correspond with the statement for public footpath 89. Whilst the user evidence is supportive of the public asserting a right over the section of route A to B on foot, the evidence of use is insufficient to support the addition of a public footpath for the section of route marked B to C based on the user evidence. In relation to the section of route marked B to D, the evidence of use is not considered sufficient to add the route to the definitive map based on the balance of probabilities, but when the lesser test is considered, the evidence is sufficient to reasonably allege the existence of a public footpath along the line of this section of route. Therefore, on the balance of probabilities, the line of current public footpath 89 Biddulph should be modified and extended along the line of the applied for route marked A to B to C, and the route marked B to D should be added to the definitive map and statement as a public footpath based on reasonable allegation. Therefore, to conclude, officer's recommendation is that an order should be made to modify the particulars of the map by showing the full extent of existing public footpath 89 Biddulph Town along the line of the route marked A to B to C on the definitive map. In addition, it is officer's recommendation that an order be made to add a public footpath along the line of the route marked B to D to the definitive map and statement with a minimum width of 1.5 metres. Thank you, and I'm happy to take any questions.
Thank you, Hannah. That's we've got a slightly different one here for us to discuss. Paul.
Thank you, Chair, and thank you for the report, Hannah. User evidence is low on this one, isn't it, if you go through the daily, weekly, monthly, whatever. So balance of probabilities is always subjective. We all have different views on it, sort of thing. On this one, I don't know if I can go with officer recommendation, really. They have been stopped at various times and told to go back or to continue to the end, but not used again. So on this one, I will be voting that we don't go with officer's recommendation.
Thank you. Thank you. David?
Can I just clarify, because this is quite a complex set of recommendations. We talked about the area which has now got a wall round it, so there's no access across the person's garden unless we do the sort of silly thing which happens where a public footpath may go through somebody's back door and come out through the front door. Where does this fit in with the recommendations that you're making here?
I mean, in terms of the Section 53 process and the purpose of this meeting, it's to establish whether public rights of way exist over a line, over a route that has been applied for by a member of the public. So we need to assess the evidence, either be that on historical or user evidence. In this particular case, in relation to the line of the route A to B to C, it's been brought to our attention that there is a discrepancy with the definitive map and definitive statement for public footpath 89 Biddulph. And some of the evidence that has been put forward is that the original intention was that the line of public footpath 89 would continue along the line of the applied for route A to B to C. And therefore, based on that evidence officer's recommendation is that the definitive map should be amended to reflect that evidence, but also the evidence in the definitive statement. So obviously with this section of the application, an assessment has had to be made as to whether, on the balance of probabilities, it is the definitive map or the definitive statement that needs to be amended or corrected in relation to public footpath 89 because of the discrepancy and the anomaly that we currently have with that particular route on the definitive map. So basically, obviously, in the initial instance, we are assessing the evidence as to what the evidence shows in terms of the existence of public rights of way. Of course, if there are, if matters come to light that affect the line of the route of a public right of way, that would be considered. That would not be a consideration for this this particular part of the process.
If we're to take Councillor Snape's view that we don't accept the recommendation, should we look at the recommendation in parts so that some parts we feel comfortable with and some parts we don't feel comfortable with, What's your view on how we stand if we were to come to the conclusion that we're uncomfortable with the recommendation?
The panel has the authority to make any decision it wishes. It is under no obligation to go with officer's recommendation. It can come to a different decision in terms, because there are a number of different recommendations because of the different sections of routes. Then again, the panel are free to accept part of the application or part of the recommendation, and or to reject part of the application officer's recommendation.
Sorry, Chairman, I think that's a perfect officer response, but we are in a situation where we need, in these extremely complex situations with severe legal penalties, if we don't get it right, we depend on officer recommendations on our views as a panel, and I'm slightly uncomfortable with the response that we've had.
Carolyn.
Thank you, Mr. Chairman. When I was reading through this application, I thought a little bit the same as my colleagues here. A to B to D, or footpath 89, are obviously in place, and it's been in place so that workmen can get to the mill. To me, that's an obvious, that's staying, that's nothing now to consider in a way. Whereas A to B to C, or A to C, when you read back over time, that was just a dirt path, that wasn't a road originally. And I understand why people have used it in the past when you read about there's no footpath on that road. And so it would be a safer route instead of going on a main road. But when you look back at the evidence and you see that the house wasn't used for a while and the mill was closed and not used, so people would have used it and it would have become a footpath. So that, I'm very drawn on a lot. What I would have liked to have seen, which would have really nailed it for me, is when the mill cottage was purchased, not this time, the time before even, what their boundaries were, and if anything was said on there to say that this is a public footpath, which I'm guessing, I don't know because it's not in here, it didn't say that. And when they put gates up, they would have had permission to put gates up, no one stopped them. And even seeing the sign from the county council saying this is a cul-de-sac. Well, if it was a cul-de-sac, it's not, is it now? It's a walk right through. And so there's a lot that puts me in the same line as my colleague, Councillor Snape. I'm not convinced 100% that that should be a walkway right through. I understand how, if I live there, I'd want it to be a walkway through. I absolutely agree. And it is a safer route. So I wouldn't want my children walking on a main road when there's a much easier route. So I'm very drawn, and I need pushing in a direction here.
Because this is obviously slightly not contentious, but a different one, could you again run through what the Biddulph Council have said? Are they in favour of A, B, C and D, or is the one bit less than the others? Because I think this is one that we've got to sort of take some direction from what's been said by locally. The local member is, who's the local member?
The local member is Councillor Flunder.
All right, and you've had no representation from him?
No, we've had no comments from the local member to date on the application.
So the parish council, the town council, then what have they said?
So Biddle Town Council have advised that they are in support of the application. So they have basically said that, to their knowledge, this has been an integral walk within the area for a significant number of years. And they are also of the opinion that the historical evidence does support the existence of the footpaths. So to their knowledge, this is historically a route that has been used in the local area. So they've said it was a route that was part of the Staffordshire Moorlands Western Edges Walk. Their understanding is that the route originally ran along the line of the route A to B to C, and that it was supplemented by a shortcut which formed the route of the line marked B to D. So they're of the opinion, the view that the alleged routes not being recorded on the definitive map and statement of public rights of way in the first place was an omission and an error that dated back from the 1950s. So that's really basically the summation of their evidence that they've put forward.
Right, thank you. And just one final one. I did notice in the paperwork it mentions a book. Whose book was it, and which of the was it? A, B, C, D in that?
Yes, there were a number of leaflets that were put forward in relation to local walks within the area. So yeah, there were a number of sample walking guides and leaflets and maps that were provided. So one of the extracts provided was a book from a book called Walks Around Biddulph, which was written by the local footpath secretary of the Ramblers Association at the instigation of Biddle Town Council, and that was published in 1995. So it does refer to a route starting from Grange Road by the Talbot Inn and crossing over to where Mill Cottage is to reach Hurst Road. So it's understood that at the time, also as well within the evidence was put forward that Staffordshire Moorlands District Council had previously been of the understanding that there was a public footpath there along the line of the applied for routes and had put signage up. It was only on consulting with the county council where it became evident that actually the applied for routes are not actually recorded on the definitive map and statement, so therefore are not officially recorded as public footpaths, and the signage was then taken down by the district council, is our understanding.
Thank you for that. That's clarified it. I will be going along with the officer's recommendation. Yes, certainly.
Why did we put up a sign then, we being the county council, to say it was a cul-de-sac?
Because essentially, public footpath 89 is currently a cul-de-sac route depicted on the definitive map. So the signs in relation to that relate to public footpath 89, because once you reach the eastern side of it, it is a cul-de-sac. There's no official public footpath continuing along the line, hence why there are signs up there to say it's a no-through route, because of how public footpath 89 is currently recorded on the definitive map.
So yeah, there's no argument that that is a route. The fight here is whether that route now carries on to Hurst Road, was it?
Yes.
Did you see the Mill Cottage boundaries on when they purchased the house? Do you get to see anything like that?
No, we are very kind of reliant on the documents that get submitted to us from the applicant on submission of the application.
Okay, I'm still torn. I haven't made a decision yet. I'm sorry.
Right. David.
I'm getting confused on which end we're looking at. Where you come to the cul-de-sac point, does the area which is beyond there, which I think is the area that we're all uncomfortable about, does that actually go through the Mill Cottage end?
Yes, so the applied for routes go through the land in the ownership of Mill Cottage. So the applied for routes would run up past in front of the property to connect to Hurst Road.
So, because that's not formally approved with the evidence that we need to continue the footpath through the grounds, that would be an unreasonable act, I would have thought, on our part. Without we approved the application as a cul-de-sac, and then it was left for someone to make a recommendation to this committee for a diversion, taking it round the footpath, round the cottage. But I wouldn't say that that was Mill Cottage's obligation to do that, because it isn't a definitive footpath through the grounds of their property. In which case, I don't quite know where we go to from that point. I'm comfortable to approve it as a cul-de-sac, but I'm uncomfortable about it going through someone's property when it isn't at the moment clearly defined as being a route that's acceptable. We're producing a burden on the owners of Mill Cottage, which wasn't there at the time they bought it and isn't there as a definitive footpath. Unless you can give me some clarity on that, I'm uncomfortable.
Could I just say, in terms of the training we've had, that is something that isn't for this committee to consider. We should be considering, is this a footpath? And then whatever happens thereafter is up to the landowner to decide. So it's not our job to do that.
Chairman, perhaps I wasn't being clear. I think that the evidence on footpath up to the end of the cul-de-sac we're comfortable about, that it's a cul-de-sac and that's fine. But we're not comfortable with the fact that we're creating a footpath through somebody's garden. I don't think that's something that I feel comfortable about us doing.
I've got Paul first and then Carolyn.
I think, David, we're not saying we're creating a footpath, we're saying the footpath's already been there. That's what the evidence is. Because the evidence submitted is basically saying the footpath has already been there, and we're just asking it to be put onto the map, really. That's what's being said. So are we saying the footpath has already been there, or has not already been there? That's the question, really. We're not creating a new footpath. We're just saying, is one there previously, and we're going to put it on the map. If we're saying it's not there previously because of Mill Cottage, etc., then we turn it down. And as the chair has said, if we're saying it's already been there, then we've got to go ahead with it, and then it's down to the occupants of the farm to go diversion order in the future. And that's really, I think, the point that I think we're arguing over.
I accept the point that Paul's making, but the thing I'm concerned about is that it is defined as a footpath through usage. I'd be interested to know how they're doing it with the wall that's up there, but it isn't there as something which has been definitively defined as a through route, in which case we are effectively creating something that we don't have.
That is why I'm
evidence.
saying I can't agree, because I'm saying it's, to me, the evidence isn't sufficient to say it's already been there. That's why I can't vote with Of's recommendation on it.
Can we have Carolyn?
Thank you, Mr. Chairman. Can we all look at page 427? So 427 to me shows clearly the footpath 89, A, B, D, David. So that makes it clearer. That's in place. That's there. We're not changing that no matter what. We're discussing whether A can go to C and B can go to C, where they've put up gates, they've put up signs, even the county has put up signs saying this is a cul-de-sac. So this is where I think we need to discuss. Do we allow the route to go from B to C and A to C? There is no other discussion in my view. So I'm still, and one or the other needs my vote, and I'm still unsure because that route was set up for the mill. To me, that's obvious. But the people who've lived at Mill Cottage in the past have not minded people walking past. But the ones who have bought it this time do. They've been allowed to put up gates, no objection anywhere, and the county even put up the sign to support them, no objection anywhere. There is so much evidence to say, we've bought it now, we don't want people on here. They've delivered, hand-delivered to every house saying, this is not a walkway through. Please don't use it without our permission. Now, if their boundary says that isn't a walkway through, this is just like I've walked over Stafford Castle grounds that's been a dumping ground forever, walking my dogs. But when they want that back to do something with it, they won't class that as a walkway. But I walk my dogs over there, but they won't. But there's a walkway. We've done it for years. So why should we put that on these guys? They obviously don't want it. I'm still with Paul. I'm sorry, I'm still with Paul.
Can we take a vote on this then? Well, not take a vote. We've got a proposal from Paul. Well, shall I take the chair then and say I propose that we go with the officer's recommendation on this? On both sections. I think the reason being is that it does say path on B to D on this map that Carolyn's just pointed out. We aren't here to fight the battles for landowners. We're here to look at the pathways. And to me, the evidence is sufficient to say that there are definitive pathways there that need putting onto the map. I think I've put a lot of weight on the Biddulph Town Council because they are the guys on the ground, and that's why we asked them. So I'm proposing that we go with the officer's recommendation. Can I have a seconder? No? Okay.
Can I suggest, Chairman, that on the basis of the discussion that we've had today and the concerns that members have had, that we defer this application rather than us trying to determine it and bring it back to the next meeting so that we can have clarity on the points we've shown concern on.
What points would you want to defer it on?
Well, I think all three of us have raised concerns.
Is that an option?
I believe that is something that we could possibly arrange.
Are you proposing a site visit?
I'll second. I'll second, because I can't
Okay.
make my mind up.
Okay. Well, if we've got a proposal for site visit, we've finished discussion now. So, are we in favour of a site visit? Okay. Thank you for that. And I think in the meantime, if we could just see the boundaries or at the site visit the boundaries, it would help, particularly for, as requested by Councillor Trowbridge. Okay, thank you. Yeah.
It's in here then, sort of thing.
Well,
As we do at the main planning meeting.
leave it to the officers to decide
Yeah.
what's the best way of doing it. Okay, many thanks. There's no exclusion of the public, so thank you for that. It's an interesting exercise. Can I just very quickly, going back to the point of a site visit, can you give us plenty of notice so we know what's going on? Thank you.